great weekend. If you guys didn't know, it was my birthday this past Sunday. I know, yeah. Sorry? 21 now. Yeah, it's the golden age. I'm very happy. No, but okay, I'm not it's just 21. But yeah, it is fun. But today we're gonna be doing a plead your case. If you guys came to the meeting, I think it was 2 weeks ago, we played this activity, but we had like a lot of fun. So we're just gonna do it again because it's a fun game. So we're just gonna be doing it again. First, we're gonna get to the reports, and we get straight into the game, just so we can get straight into the action. But we'll start with my report first. Two things on my mind. Right now, we're working on study merch. I've been working with some on-campus ambassadors for with Thresh Prints. They've been making some designs for us, as well as Isabel, like working back and forth with some of the design. So I wanted to go for like, I don't know, I wanted to like let my creative juices flow with this design. So I used to work at Black Sun, and I used to like look at like a lot of Brandy merch. And so uh sorry, so I used to look at like a lot of the Brandy merch. And so I noticed they always like kind of like this kind of font with like a little arch on the top and like a little like the little location on the bottom. And I was like, oh, this is tough. So I feel like if I made one for Lost Society, that'd be super cool. We will also have either this same design or a different design on a t-shirt. If you are a due paying member, a t-shirt would come free with your dues. So congratulations on that. As for the sweatshirt, that'll come separately. Based on estimates that I've been getting, we probably charge maybe 35 for the sweaters, which is not bad at all. Once I can get a final price, because Long Beach is taxing for me using the logo and the thing, which is kind of annoying. But once I can get that final price, I'll make a Google form. It'll be like an interest form / pre-order, and then we can go from there. That's with the merch. Second thing, I've been talking to a couple of you guys individually, and I just want to let you know that Law Society will be starting a law review. I don't know if you guys are familiar with what a law review is, but essentially it is a large research paper / journal with articles that come out of law schools and prestigious undergraduate schools. They tried to start a law review here at Long Beach State about 13 years ago, but it fell through because there wasn't enough of strong force from the ground up. And so, considering the fact that we've already done like the LSAT prep classes, we just became a registered mock trial team on campus. I don't see any reason why we wouldn't have the manpower and the strength to start a law review. We are currently in the process of trying to find not just professors at our school, professors at other schools, or maybe attorneys in the Long Beach area who would want to publish their article through our forum. But what this looks like for students who, if any of you guys are interested, would look like editing, blue book noting, and writing your own comments and notes attached to the article. So that when it gets officially published through our school's political science department, your name would be attached right onto it. And these are some of the most prestigious pieces of literature that can come out of a university, period. And so the fact that we might actually have the opportunity to have this at Long Beach State is insane. But right now, I'm going to be making the interest form for attorneys who would like to publish an article. If you guys know about any attorneys who are interested in writing an article through Long Beach State, let me know. And then from there, we'll make the application form for people who would like to be on the editing staff for this. But yeah, is there any questions about that? I know that's like a lot, but I'm down to answer any questions either right now or after. No? Okay, perfect. But yeah, that's gonna be our next project. You can see some updates on that soon. It's gonna be kind of low key for now. Just waiting for Dr. Perkins to respond to my emails. Dr. Perkins is the chair of our department, the political science department, just so we can actually make it an official publication and not just a student passion project, you know? But yeah, that's about it from my report. Oh, it doesn't look like she had anything to report and nothing. Okay.
Yeah, for as you guys know, we have an upcoming pumpkin carving event, Pumpkin Bash, and it's gonna be on the 29th at 5 p.m. So bring a costume as well because we're gonna have a $5 Starbucks gift card for the winner of the best costume. I know Nick is gonna bring a crazy costume as you mentioned last time.
You guys are not beating my costume. I'm just saying.
But yeah, so that's upcoming on the 29th. And bring friends. Yeah, bring friends, bring as many people as you can, or however many you want. And yeah, let's have a good time. So hope you guys are excited for that. And no, you're good.
Oh, yeah. So for those of you who applied to our intern interview, here's just some basic info. So I got a couple questions. They will be through Zoom. So I will be sending you a link. And if you haven't seen your email yet, or like confirmed your email, like appointment, sorry, your email appointment, please do so that we can get you in for the rest of the week. And just a helpful tip, just be prepared and make sure you look over your resume and all the stuff that you submitted because we will be asking on that. So
And this only applies to the outreach internship position.
Yeah.
Yeah, okay. So if you apply to like any of the other internship positions and you didn't get an email and she's saying like you should have received an email, don't fret. This is only regarding the outreach internship. Anything else? No, that's good. Okay.
Oh yeah, and so if you guys can scan the QR code and do the attendance, I see all you guys doing it already. So thank you for doing that.
Perfect. So yes,
Are you good? Are they good?
let's give them a second. Okay, yeah. Yeah, honestly, once we get to the activity, you just fill it out with the one. Yeah. From Ida, our director of academic development, aka the person that's in charge of hosting our LSAT preparation program. Our next class is on the 28th, aka the day before our Halloween event. I really hope you guys can come out. We will be continuing conditional statements. From my own personal experience when it comes to conditional statements within the LSAT, they are a little more difficult to gain a grasp on. So if you're able to come, if you're again only open for due paying members, but if you are able to come and you do want to at least get some sort of head start on the LSAT, this would be a huge opportunity. Initial statements are not easy to understand by yourself, and so having not just Ida up there, but Cesar, her Ida's assistant for teaching the program, it would be a huge help not just for yourself, but for the people around you as well, as it is foundational on its community. But yeah, that looks like it's about it. And it's going to be in this room as well. Yeah. Okay, so this is from, I believe, Ida, and so Director of Academic Development and our Vice President of Finance. This is their internship portal. I think they are still taking applications. If you didn't already apply, there's the QR code, but I believe they're already in the process of sending out emails as well. If you haven't, you could reach out to any of them. I know the contact information is also in the Discord, but that's about it from their report. Any questions? Okay, good. I can't really answer the questions anyways. Okay.
Oh.
No, I mean, I think it's just straight to the activity at this point. Yeah.
All right, guys. So for those of you who were here last time, thank you for coming back. I know a couple of you guys were pretty excited about this activity, and a lot of you guys had a lot of fun with it. But basically, plead your case is the activity of today. I'm gonna go ahead and get you guys into groups of 4, preferably not with people that you know, just to make it a little bit more fun, a little bit more social, meet new people, and also be able to work with people that you haven't before. So I'm gonna go ahead and start naming off, or 1, 2, 3, 4 groups of 4. And then, so, sorry. If you're 1, go into the group of 1. And then if you're 2, go into the group of 4. 2, 3, 3, 4. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. And then everyone, yeah. Oh, 1 come over here, and then 2 can be in the back corner right here. 3 in the middle right here. 4 in the back corner right here, and then 5 right here.
Right.
Okay, you guys ready? Before we go ahead and read all of these, sorry to interrupt, but for just the base ground rules, we're gonna have two people suing each other and they will be handed the case, which was just handed. Details about the incident, both the plaintiff and the defendant will have one lawyer. So there's gonna be a lawyer, a plaintiff lawyer, defendant lawyer, a plaintiff, and a defendant. And then basically at the end of 15, you guys will have 15 minutes to prepare your case. So read through, prepare your case. Feel free to be creative about it. You know, get in different angles and stuff. So like you could countersue, you could even settle if you feel that you're losing the case. And the judges at the end of the 15 minutes, well, sorry, you'll be able to present your case at the end of your 15 minutes of preparation. And we'll go over the times for that afterwards. But you will be presenting to the judge or me, I guess. And I'll be the final determinant on who wins after you guys both present your cases. So the defendant can build off of the defendant arguments ideas. And like I said before, don't be scared to find loopholes and be able to like kind of work your way around certain things. Yes. I'm gonna bring out my phone. Sorry, I lost the other things from last class. So you have to, while you guys are reading the thing, I'll bring out something to decide the rules. And the plaintiff and lawyer will decide how much money to request, building their argument. Defendant and lawyer will decide on a counter argument, possible defense, and strategy or settlement opportunities or strategies. 15 minutes for prep time. 10 minutes through the, or I'm gonna do around around 8 minutes through the prep time. I'm gonna throw in a curveball for you guys. So a curveball is basically gonna be like random facts about your case that you can use that the defendant or plaintiff can use to their advantage. So it could sway the case in either direction. And then yeah, after the 15 minutes, each side will present their case. And yeah, go ahead, guys. You can start reading. I'm gonna go ahead and get those roles assigned. Yeah, hop in. Isabel or Nick? Wait, one second. Isabel or Nick, do you guys want to hop in? It's gonna help. Alright. Thank you. What's up? Oh, you gotta take off like a little. Okay, no worries, no worries. Welcome back, by the way. Welcome back. I hope you're a little bit more settled in now. It's always scary going to the population.
Responsible and take full accountability for not doing it. Story. Evidence list says hospital discharge papers from the dogfight, photos of illicit wounds, control reports, frame, and the text for Kevin says, quote, "They must have done something to upset them," end quote. So in statement, I saw Ellis here job paper, she was worded, full section headed, and a job, just ran all the time, quote. Then argue ideas, and do one job first, if you like, property, worded, no history of aggression before this, and Kevin offered first aid, showing what this. Really? You're an expert. You know what to do. Well, I get you here to I just feel like I was prepared. Okay, so we're not. We're not. Hiring against each other, like each other. Do we have to split up our team?
Okay, I mean, like, if you take one side, yeah, we're trying to do it.
Even just like.
Oh, here it is. Right. We can like make that stuff. It's like degrees. There's many years.
That's what I was thinking.
Remember, you guys are kind of running against each other too. Defending the place.
Okay. So I can say.
Traffic.
Unavoidable
traffic.
Yeah.
I think you got, okay, so.
This is looking great.
Yeah.
As of now.
Look at how learned
Here's my lawyer. It was fine. Now it's fun the whole time. So.
Those, you were good. You were good. You got a background.
Physical damage.
Yeah, I'll be. Okay, well, maybe I will say. You can check.
Yeah, but. I was in. That's a little.
Okay, curveballs. For the car crash, case number 1. Maria has a prior speeding ticket last month in the same neighborhood. Security camera near the intersection shows her entering the light just as soon as it turned red. Now, it's not perfectly clear. Maria's seatbelt was unbuckled at the time of the crash, not mentioned in their deposition. The doctor's report notes some pain that may be aggravated by pre-existing back conditions. Number 2, business fraud. James declined to authorize some recommended repairs, asking for the cheapest possible fix. QuickFix has signed work order showing James installated approved for work that was actually done. James waited nearly 3 weeks before taking the car to the second mechanic, plenty of time for brake pads to wear further, and he previously posted negative reviews of other shops online, showing a pattern of disputes. Dog bite. Ella had earbuds in and may not have heard the dog barking warning before approaching. Neighbors reported seeing her occasionally jog into Kevin's yard as a shortcut. Kevin's dog has been startled earlier that day by fireworks, which may have made it agitated and more defensive. Ella initially told paramedics she might have leaned towards the dog, but later left that detail out. Property damages. Robert's fence has already been leaning due to rotting wood posts, not mentioned in his claim. The animal control report shows Robert's dog escaped before the pool construction, once before, or in the past. Neighbors had complained to Robert about his fence being unsafe prior to the incident, and weather reports show strong winds during that day. Event disaster. Samantha changed the event timeline last minute, which may have caused confusion with the food delivery. The venue's loading dock was blocked by another vendor, delaying catering setup. Guests complained. I'm gonna come by. You guys can take pictures. Samantha has rejected a suggested backup fruit plan offered in the contract, which may have prevented the problem.
You guys are close.
Yes, picture. DG is another variable.
I got that.
Right. Said I saw it. Yeah. Offering your service. Offering your service. Nothing like, you didn't get the whole, you didn't do it. I think the whole thing. You clearly got the great light. Yeah, you guys are the gas. Yeah.
No, it's just like.
No, it would be 1,000. We're gonna We'll play a role. You guys should we start? Let's start. You guys got it. Oh, no, you're sorry, I didn't realize.
Was it like, oh. Yes. Okay, I think so. Judges.
They don't have to plug in. Yeah, we also have evidence. We changed it the last time. No, that is only information. I think. You guys think I'm not so? I was worried about Don't ask for too much money. Explain the bad. I said, don't. That's directed by. Rules though, like you didn't know Yeah. What was the question? That's how. One minute. Oh, you want? Yeah. Oh. You will say.
Isabel, do you want to be a judge with me? I can put you guys first, so you guys can go first.
No, we know.
Trying to settle, like showing them information and like counter argument to the plaintiff's lawyer, and then honestly just like go from there to try and settle, arguing their case, saying that it doesn't matter. Yeah, but you have to find like facts against their case that's like Yeah. Okay. Then, yeah, pretty much. Yeah, I wanna. Yeah, you just want to settle for whatever. He's a good actor. He's a good actor.
Well, this, oh, that was the.
Time.
Yeah.
All right, you guys ready? I think we're gonna. Do you want to join, or do you want to stay with the case? It's either one. Because you guys have 5 people.
You're so passionate. No, it's because like there's 5 of us and there's only 4 people.
It's okay.
Yeah, it's not that much, it's really sad.
Okay, then you guys just stay for the first case. You guys.
Yeah, because they for you. No, this is. Yeah.
Evidence.
Emotional damage.
Yes.
You guys get an extra.
And then we apologize.
And like, you work out the efficient on like. And then what about like? Yeah, 1,500 for that. And then 500 for emotional damage, like the biggest deal on my life. Oh, that's something we didn't know about it.
Okay, we have case 5. Okay, everyone ready? We have our first case.
Wait, am I good?
You want to? Okay.
Yeah. So this is not. This is the last. Basically, we're just gonna be like writing down.
Right, take a. You fill up a.
Wait,
Yeah, let me get you a pencil.
do it for any intent.
Well, it's fine.
Oh, I got.
Here's now.
I keep doing.
Oh, my bad. Oh, I did. Sorry.
Oh, you're good.
Yeah, sorry, I don't know.
And then. That's funny a little bit.
Used to be like.
All right, everybody, trial phase. Plaintiff and lawyer decide how much money to request and build their argument. Opening statements are gonna be 4 minutes each. Evidence presentation is gonna be 45, or sorry, no, not 4 minutes, sorry. 1 minute each. Opening statements are 1 minute. Evidence presentation, 30 seconds. Short cross-examination. Each lawyer can ask 2 to 3 questions. Closing arguments are gonna be 45 seconds, or 1 minute. I'm gonna move that to 1 minute actually, because they normally take a while. Closing arguments is gonna go to 1 minute, and yeah, good luck. Can we start with the plaintiff? What is your opening statement?
Oh, do I sign up first?
The plaintiff lawyer, yeah.
Okay. Your Honor and members of the jury, on the biggest day of my client Samantha Green's life, her wedding reception was ruined by Perfect Plates Catering. They were late to fulfill their service, and we have photo evidence to prove that buffet tables were empty. And there was poor communication all throughout the service. And today we will be suing them for $1,500 for the service that was unfulfilled and additional $500 for emotional damage that Perfect Plates has caused on my client's life.
Thank you. Go ahead.
All right, members of the jury. The plaintiff argues that there was a lack of communication throughout this entire ordeal. However, Samantha had changed the original timeline of the schedule, which had caused us to be late initially to the wedding venue. And there was delay of traffic and unavoidable circumstances because that the venue's loading dock was blocked by another vendor. And they're suing for emotional damage because we had ruined their wedding day. However, it really wasn't because of us. It was more because of another incident with the DJ at the scene, and there was no other backup plan offered for the food incident. And we had proposed other ways to mitigate this problem, but they had not taken up this instance.
I have a quick question for the what was the DJ? How was the DJ?
The DJ was the reason why the family and friends had initially left the venue because the food hadn't been served yet. And they left because of the DJ.
Mm. And then now could we get an evidence presentation from the plaintiff?
Do I start?
Go ahead.
Okay, the photos that you guys see here would show that the fulfillment of the catering was poorly done. The photos show that there was empty buffet tables, suggesting that the service was not properly accordance to the contract. And although the defendant here shares that there was a proposal for a backup contract or backup service, they were asking for an additional $1,000, which is not something that we could afford. And although they proposed that backup plan, they were still poorly communicating throughout the whole process, and if they did not fulfill their catering, initial catering, then they would not be able to fulfill their backup plan as well.
Right. Okay. So the photos with the empty buffet plates, those were taken earlier, and there was no specified. There was a mix up with the timeline schedule, and the guests statement said that we left before the food was served, and a witness even said that although the food was late, the DJ messed up too, and that the guests started to leave before the food was been scheduled, so it wasn't entirely the caterer's fault. And the food was delivered. It wasn't, although it may have been late, it was not completely missed. It wasn't a total failure, and the food still got to the venue eventually.
Thank you. And now for cross-examination. So you guys can ask each other a few questions.
I'm asking the defendant.
Yeah.
Okay. Defendant, good evening. What was the reason for the lack of communication in the process of fulfilling your catering for the wedding?
Yeah, we were like in traffic. There was fortunately no signal at that time. So while we were driving towards the venue, there's an apparent accident up ahead, which caused the foreseen traffic or whatever. But yeah, there was no signal.
The photos of the empty buffet tables, those were actually taken during the wedding. This was after you guys left in your poor service. What was the reason for those empty buffet tables and the failure to commit to the contract of a full buffet service?
Oh, everything finished everything. Like the remaining took home, you know, some of them took home for her family, you know, and the rest, there's of course it was empty, like there's not that many people, so why waste any food?
No further questions.
All right. Samantha? So it's hard. In a catering contract, it doesn't explicitly guarantee delivery time, but you still expected a certain time, is that correct?
It does in the contract when we signed it, but like not in the case file. Like it was,
So there's
it was expected during the wedding. That's what we know.
There was a general expectance of this time,
Yeah,
but not firmly in the contract. Yes.
there was expected, and that, but also
A specific time.
yes, during the wedding.
Why did you not opt in for the backup food option?
Because I couldn't. Why would I? I couldn't afford it since the wedding was already expensive, and I wouldn't be able to opt into it in time.
Do you truly believe?
It's 2 questions.
Oh, 2 to 3.
Oh,
Mm,
thought it was 2 questions.
I got 2 questions. So, thanks for that.
And now for the closing arguments, please, for 45 seconds each.
Whenever you're ready.
Your Honor, and Your Honor, members of the jury, this was the biggest day of Samantha's life. And although there were some other circumstances, the fulfillment of the catering was poorly done. There was lack of communication. There might have been people who did leave early, but that does not invalidate Samantha's feelings and the emotional damage that she has been experienced as a result to this poor catering. And additionally, my client did have to seek out emotional support for this, and that's the reason why we're suing for emotional damage as well.
Was there evidence for that?
It's my turn to speak.
Go ahead.
So although communication was lackluster on both ends, we are willing yeah, we are willing to settle for the buffet damage, the physical damage of the buffet not being delivered in a timely manner for $1,000. However, for the emotional distress, I don't think that is quite warranted. And although, because it wasn't totally on our end, we are willing to settle for $100 on that aspect. But it is mainly in part of other circumstances that aren't directly in our responsibility.
Thank you. Some time to this time, real quick. Okay.
That was hard. Hey, that was good. I love this. Honor, this is propaganda. Your Honor, this is propaganda. That was good though. That question you asked was good.
On the time.
I didn't know whether to say yes or no. I didn't know whether to say yes or no. I just kept saying like,
Go to the contract.
So I'm like, I'm not gonna say yes or no. I just said it was in the contract. I'm not gonna move like.
My intention is to keep up with it.
You said like you ate the food.
I was like, all that.
Okay.
Oh, okay.
Yeah.
No, it's okay, everybody.
Okay, it's okay. Cause they ate the food, bro.
Once you're on the jury, they're allowed.
What are they gonna do? Kick you off?
But it's
Like, I can't, that one's already confirmed as a jury.
In silence.
Bro, alright, it's so hard to conclude. What we thought.
The jury on side with the plaintiff
Hey.
for $500 in emotional damage. We would have taken your $1,000 settlement. However, seeing that your service was fulfilled, however, and when you asked questions, she asked you, was there a specific time? You said during the wedding. So there's seeing that the DJ also took part in why party members left before the catering actually came. We're seeing a $500 emotional settlement. Also, you guys took food home from the wedding.
Yeah, there
There's
was
no
no
evidence.
mention,
There
there
was
was
no
no
evidence.
mention. There was there was no mention of the food that was missing or like that wasn't enough. Yeah, from the venue.
Like that shit.
Seeing that, we won't take your $1,000 settlement, instead it'll be 500 still.
We still got her band. We still got her.
Y'all should have settled
It's
before,
reverse,
man.
it's reverse.
Huh?
Should have been reverse.
Oh,
No,
Oh, like you're the-
emotional.
Well, thank you guys.
Still got her band.
The only people who actually want to employ.
Oh yeah, also seeing that the food was there on time because of like traffic and reasons.
Yeah.
Well, I was thinking about that too.
We still got her band, that's what I'm saying. Yeah.
Alright, can we have the dogfight case?
dog bite. Who's next? Group one.
Dog bite. Okay. Trial phase. Opening statements, 45 seconds. Evidence presentation, 30 seconds. Cross-examination, 2 questions. Closing argument, 45 seconds. Can we start with the plaintiff for an opening statement?
Ladies and gentlemen of the court, we are here today searching $50,000 for emotional, physical, and property damages to my client Marie as a result of Jake's distracted driving. Now, let me set the scene for you. Marie's going home or a little late for work. She's speeding in her own neighborhood. She gets to a yellow light and she proceeds into the intersection when Jake, on his phone, might I add you, runs into the intersection and hits her passenger side, causing her to spin out violently, leaving her with immense back pain and having to miss work. And on top of that, her car is totaled and will not drive. He is clearly at fault, and there is no other reason than to find him guilty for the charges.
What was the amount you guys said again? Sorry.
50,000 for car, emotional, physical, and medical.
We good? Okay, members of the jury, I'm actually not sure why he stated that she was late for work when it clearly says that she was driving home. Why are you speeding when there's a yellow light? By law, you're supposed to slow down. Let's see what else. There is no actual concrete evidence that my client was on his phone. So, let's see what else. Wait, not much I can say. The severity of the accident was because of her recklessness. Her speeding caused the major impact of the crash. If he was speeding, which I don't think there's any mention of that, she would have been launched very far, which there's no mention of that either. Okay, wait, okay, I'm done.
And now for evidence presentation, please.
Okay. So we have a witness who was on the corner and saw the whole thing play out. Not only does he say that he saw Jake over here looking down at his phone, they claim that Marie entered on a yellow light. Now, if you know anything about traffic law, you know that as long as your front 2 tires are over the line, that gives you full right of way when you're crossing into the intersection. The other evidence at play is that a doctor's note said that she had whiplash as a direct result of the accident. Now, they're going to claim that she had back pain prior. Who doesn't have a little bit of back pain? And whiplash came from a direct result of the car crash. And although they're also going to claim that she had a speeding ticket a month prior, who doesn't get speeding tickets? Everybody gets tickets. It's a common occurrence, and it doesn't justify the actions within this case, and it doesn't change the facts that he is still at fault.
Okay. Members of the jury, you guys claim that, I'm sorry, the plaintiff claims that you clearly had a green light, but the witness stated that it was a yellow light. What citizen doesn't have a speeding ticket? My client doesn't have a speeding ticket, actually, so I don't know what you're talking about. And who doesn't have a little back pain? Your client seems to be a healthy young woman, so I'm not sure why she would have. Okay, well, she previously got a speeding ticket. She previously was known for having pain, so you can't really blame all of her pain on my client if she had it previously through something else. Why are you speeding? Okay, yeah, we're good. Yeah.
Now for the 2 questions for the plaintiff.
Hi, Jake.
Yo.
What were you looking at on your phone when you entered the intersection and struck my client?
I was on.
The witness statement says that you were.
No, the witness said that I glanced down. Well, his.
So the witness statement does say you were on. You said you weren't.
Yeah, I was on.
You said you weren't. Were you or were you not on your phone? The evidence also stated that within a few minutes of the crash, you were sending text messages.
Okay, yes, I did send a message. The evidence I did send a message before, but I did, and it says that I glanced, but I wasn't glancing at my phone. What was Maria also claims I was on my phone, but as
Two against one.
no. She claimed that it was a green
Do
light.
you have evidence?
Yes, the witness said it was a yellow light, and then what else? There was the camera, right?
There was no camera.
No,
There was.
Yeah, he was on his phone.
There was a recording, but it was.
with the camera. Yeah, there's no evidence.
Defendant glanced at his phone and was also sent text few minutes earlier. Next question, please.
Okay. How fast did you press on the how much did you get to press on the gas pedal going at such a speed that you struck Maria, causing her to spin out?
Okay, that's the thing. She was speeding. She was going really fast. I was not. No. Yeah, I hit her. She came out.
She got it right there.
Well, yeah, wait, but was it really right of her to speed across?
It doesn't matter if it's right, it's a matter of way.
Yeah.
Thank you. And now for the defendant for 2 questions, please.
So in the deposition, you didn't mention that your seatbelt wasn't on. Why weren't you wearing your seatbelt on the way home?
Yeah, I live around the corner, so that was my mistake, but I thought I was just gonna get home safely, and so I motioned to take off my seatbelt and.
While you're driving in an intersection, you take off your seatbelt.
No, I had my seatbelt, like, I was pressing the button and then.
While you're driving, you're pressing.
Yes,
the button.
one hand was, yes.
2 hands are supposed to be on the wheel while you're driving.
That's.
But you said that, okay, so last month, you got a speeding ticket in the same area. Why are you such in a rush to get home?
So that time I was about to get home and I had gotten a call before. And my grandpa had fallen in my house, so I was speeding. It was completely a one-time scenario. That's my first speeding ticket I've ever gotten.
But now you're gonna get another.
No, I'm not here for a speeding ticket. I'm here because.
But you
of my
could have
opinion.
gotten one because in a residential area, the speed limit is typically 35 miles per hour, right or wrong? 25 miles per hour.
That is
No. Yeah, I was gonna say. Thank you. Sorry. And closing statements for 30 seconds, please.
All right, it's clearly shown that Jake was not only at fault, he was distracted and careless. Part of what happened after the crash is that he was very dismissive. He didn't really care what had happened. And that same behavior is reflected today in his statements. All right. Marie is going to suffer as a direct result of his actions, and he is solely liable for them. It doesn't matter whether or not she was speeding when his actions of being distracted on his phone and accelerating in an intersection are the sole cause of it.
30 seconds.
My client is not guilty.
All right, thank you. All right. I think I know.
Okay. I think I agree with everything he says.
Okay. So,
Literally, my lecture got such a strong pace pump, and like, got put on the spot. I know, so just like, I'm like,
All right, thank you for the plaintiff and defendant. The jury favors the plaintiff. The jury will award the plaintiff not $50,000, but $45,000 for their car and emotional support. However, seeing that the plaintiff was not wearing her seatbelt in the on her drive, we will be denying her $5,000 worth of hospital care. Thank you. Hey, where do you sleep on next time?
Okay.
All right, next case, you guys.
Wait, you grab me? I don't.
Okay. Yeah. You start throwing that way, then you just let it come on, like, well, because I was bringing earbuds on me, I can't. Okay, we start with. Sometimes. Hold on the phone. Can we start with plaintiff, please?
Okay.
Please have your opening argument for the dog bite incident, right?
Yep. And you have 20 seconds. So for time's sake, we're gonna bring everything down a little bit. Sorry, guys. But can we have 20 seconds for the opening statement starting? whenever you're ready?
Hello, everyone. So on October 5th, 2023, my client Ella Morris was on her usual neighborhood jog. When she passed her neighbor Kevin Brooks' home, Kevin's German Shepherd jumped off Kevin's property into the sidewalk, attacked Ella, bit her leg, resulting in major injury that sent her to the emergency room, required stitches, and left a huge scar that she is now self-conscious about.
Thank you. Sorry, very short time. Sorry. And defendant, please.
Your Honor, members of the jury, actions have consequences, and it is within a working dog's training to defend. Evidence will show that my plaintiff, a repeat trespasser on my client's property, finally stepped too far. The facts will show that my client's dog, a well-trained German Shepherd, was intentionally provoked when the plaintiff, Miss Morris, stuck herself in the dog's face. And testimony will prove that even though my client was not at fault for the plaintiff's injuries, she showed remorse for Mrs. Morris. Actions have consequences, and I believe the court will join Miss Morris in learning the meaning of this phrase. Thank you, Your Honor.
Thank you. So we have a 30 seconds for evidence presentation, or 20 seconds for evidence presentation.
We have hospital discharge papers confirming the dog bite, a photo of Ella's stitched wound, an animal control report showing that the dog was not restrained, and text from Kevin that says, "You must have done something to upset him," dismissing my client's pain and her injury.
And evidence.
Miss Brooks, can you tell me about your dog?
My dog's a class dog. He's very well trained and he knows to communicate very well via barks before engaging them when he was deemed a threat.
And how did you react when you found out about plaintiff's injury?
I went over to her. I asked her if she's okay. I offered her first aid, not dismissing any of her injuries emotionally and physically.
Thank you.
Thank you. Plaintiff for a 2-minute questions. Or two questions. Or one question. I'm sorry, I forgot to ask one question. I'm sorry about that.
For the defendants. So You offered first aid after the incident, just by claiming it wasn't your fault. So you were home during that day because, you know, obviously we're there to offer first aid. Were you supervising your dog during the time of this incident?
I was not inside my yard, but I was inside my house. I have big windows. I can see everything.
Well, answer the question, yes or no. Were you supervising the dog?
My dog is well trained. He does not need constant supervision. He has no past of being aggressive.
You were not
so he does
supervising
not
your
need
dog.
to be supervised
So you
every
were
day.
not supervising your dog. Thank you.
One question from Brendan, please.
Miss Morris, my client watched you stop running and lean over towards the dog. Is this true?
No.
Well, you say this is not true, yet Miss Morris, when a pandemic, not pandemic, you told a paramedic that you would lean towards the dog.
I feel like this is more than one question. I feel my client already answered the first question.
And closing arguments, please. You may have 30 seconds.
I don't agree.
Yeah. That's it.
How much?
30 seconds. You're ready.
Ladies and gentlemen, my client was fully aware of the situation, was jogging on the sidewalk. The dog was angry due to fireworks earlier that day, which the owner admits, not supervising the dog, knew about the fireworks, was home when those fireworks went off, knew the dog was dangerous because it was worried about those fireworks, did not secure it, did not supervise it even, left it out in the yard to just do whatever it wanted, and it decided to attack my client. We are asking for the defendant to pay for my client's medical bills, as well as some extra $2,000 for emotional compensation over the damages.
How much medical bill? Sorry.
The medical bills were $5,000 due to the need for stitches.
And what was the?
$2,000 for emotional damages due to the distress and fear felt by my client.
Got it. Thank you.
Your Honor, members of the jury, I find it very interesting how the plaintiff's lawyer brings up these fireworks that happened much earlier in the day, far from the time of the attack. And I also find it interesting that they claim that this dog was so unsupervised, like a wild animal, when my client clearly shows that the dog is very well trained, doesn't need constant supervision. My client even took the dog on a walk earlier that day, letting out all the frustrations that may have even been caused by those fireworks earlier. Again, actions have consequences, and it's within a working dog's training to defend. Thank you.
I don't want.
Yeah, no, good job, good job. Did exactly what I tried you to do. For all future lawyers. Fun fact about witness training. Witness training involves telling your witness, say nothing. If you get asked a question, just stick with your story. I had two really great questions. I would pick. So that first question was going to be my second question. The other one was. Were you aware of the fireworks that happened previously today? If they said yes, I was going to be like, so you left your dog out unrestrained, even though you knew your dog was stressed. And if they said no, I wasn't aware, I was like, so you're lying because you were home to offer first aid, and yet you're saying you didn't know about the fireworks. Like, how could you not hear some crazy about fireworks unless you're actively not paying attention? It's like how you can just go off. But it did my class. And also, this other one was a trap because if she had said yes, I was supervising my dog, I was like, so you didn't stop your dog from biting my client? Yeah, no, it was dependent entirely on what the answer to the question was. That's all perfect. You did great. You did amazing. Bro tried to ask follow-up question. I was like, Judge, that's not allowed.
No, that was good. That was good. Thank God.
I thought it was. 20 seconds per speech. I went back to my debate days. You gotta like speak at 10 miles per minute, man. Come on, get arguments out that. Yeah, that one question fucked this you up. I heard one question, was like, all right, I have a good question. And I had already told her, if he asks you anything, just say no. Don't respond to him. If I was able to get that second question. Oh, yeah, no, I probably. I'll put it around me to go. Second question was, she told the paramedic that she needed. So, so my like the intent was.
Say that, you think that my whole life, that's not true.
Oh, yeah, we were talking about like, if you brought that up. We're gonna say, well, maybe I did a little more, but we're gonna say like the thing, what the witness saw was her. And herself. It was actually, yeah, we were like, she put her arm out because she was defending herself, not because she was like trying to pet it, she was terrified, the dog was barking at her. If I brought up the earbud thing, I was gonna be like, your earbud, you're not noise canceling headphones. You can hear an angry loud dog. The German Shepherds are huge dogs, not tiny dogs. I was also gonna say, even then, you can also see the dog. If you're saying, lean over, obviously she was seen by the dog.
Order. All right. The jury has decided, and the jury rules in favor. Hi, everyone. The jury has decided, and the jury rules in favor of the plaintiff. However, the defendant will be awarded $5,000 for the medical fee. However, emotional fee will be discarded, and you guys will be getting no emotional fee. And the only money you guys will be getting will go towards the hospital bills. Thank you very much. Very strong case, really good choice. You guys have like. Yeah.
That's your experience.
Hi, judges. Ready?
Okay, so
Case two.
What's your guys' title?
The mechanic.
All right, can we start with the plaintiff for 30-second opening statement?
Your Honor, and people of the jury, my client, James, is a hard-working class American who just needed a car repair and just wanted to have a swift job done, easy like that. But this auto repair shop, as they claim, it has falsified invoices for my client and made no repair or made faulty repair and then made faulty repair and
Despite the plaintiff's claims that no repairs were made, the clear evidence of the fact that his old brake pads were in his trunk begged to differ. And a transmission flush on its own, one of the repairs that was made, is not exactly something that one could easily distinguish after having to repair them. Perhaps if the plaintiff wasn't purely interested in the littlest possible deal and heeded my client's recommendations for further repairs, the repairs to the vehicle would have been more substantial and more easily recognizable. As for the delays, many factors can contribute to an extended amount of time in the shop, ordering the parts required, or even other possible complications with the vehicle itself.
And now for 20 seconds for evidence presentation.
Quick in the auto repair shop had history for car repair and poor and faulty car repair. They're invoices from Quick Fix that were and mechanic number 2 confirmed that there are no signs of transmission or brake, for brake repair.
You claim the brakes installed were not new according to the second mechanic you consulted, but after being used for 3 weeks straight, you clearly wouldn't be able to tell the brakes had just been recently installed. James has left negative reviews on multiple other mechanic shops and has left one of Quick Fix itself as well. With a history of disappointment, who's to say he is the best judge of quality work? Thank you.
Now for the plaintiff, can we have two questions to ask? Or one, sorry, can we bring it down to one question? Thank you.
So I would like to, you say, or you and your attorney claim that that the break between installment and the 3 week should be changed over time. But as you guys know, that's clearly not true. Brakes do not cannot be damaged that quickly within 3 weeks. I just want to know why you guys would make such false statements.
Yes, they can. 3 weeks is a long time, especially if your client drives and commutes for long periods of time. Of course, the brakes are they're gonna have noticeable changes. They're not gonna.
All right, thank you. Is there any questions?
Mr. Patel, did you or did you not come to Quick Fix seeking, quote, cheap deals?
No.
Oh,
There's only one question, Jason.
that's what it is. Okay. Well, then it would be fair to assume, since you did earlier, that you know, you wouldn't be that dissatisfied with quality repair.
Okay, thank you.
Thank you.
Now for a closing statement.
Your Honor, the jury, all we want is a simple car repair, free on the company, and 10K in emotional damages. Because my client went out of work or did not have the car for a bit, and the whole trial was just so much on their mental health. We just really want the free car repair and the 10K.
Thank you.
On account of James Patel's damaging reviews of the Quick Fix's business, we would like to countersue for $67 on account of damage claim.
$67?
Yeah, just and it's wait.
All right, thank you guys. Sorry. You guys talk so you guys can't hear us. One please let us know. So here's no. This is new crop that we should play it.
I did.
Yeah. There's like this. And then we were looking for T2.
No, but I asked.
That is correct.
Speculation. That's assumption that I said. I came in and asked.
Well, yeah.
Yeah, I would in your
say you're on. Yeah. You guys feels like people are just like that's more of an argument.
Oh, I think.
Do you or do you not think you're good?
I'm not, I asked for service and you failed to provide it. You know how much it costs? And I have to go to another extent.
Emotional damages. If you wanted that, you could have specified, hey, rent to the car and you should cover all that. Emotional damage is. I learned that. You made me sad and made me cry, and I want this money because you made me.
I should.
Exactly. That's on court.
It's emotional.
Like for the plaintiff. Yeah, like 10,000.
We'd like for the plaintiff to be sent to county jail.
The value of the car. Okay. Assumptions.
MO.
Going to jail for these.
That's freedom of speech violated by rights.
Order in the court,
We're definitely-
Oh, yeah. Order in the court, please. The jury has decided
That's in a gap.
the jury orders a settlement for the defendant to pay sorry, the plaintiff to give $67 in a Twix to the defendant and for the defendant to be to give $1,000 to the plaintiff for missing work. And thank you guys very much.
Yeah, for 6 years. That has the president on your team.
I think it's fine.
So he's out of it today, so
Yeah.
he didn't grab. Isabel, you just sniped us.
Yeah.
Start with a 30-second opening argument.
People of the jury, the evidence today is going to not only show you, but prove to you that through the defendant's negligence and the contractor's careless efforts led to destruction of my client's property, which has led to not only emotional stress to their well-being, but to the physical endangerment to them and their dog. You will see through the evidence that their life is threatened and that this is a careless target from the neighbor. Thank you.
Members of the jury, we would like to opposingly say that the real neglect is of the defendant's dog and also of the gate flash fence, which was already damaged prior to the incident.
Now, it's interesting that they want to bring up negligence on behalf of us when the evidence shows tire marks next to our broken fence, when there are eyewitnesses that say they saw workers bringing in the loads of equipment and that they heard the impact of the fence. Additionally, I'll stop it there.
This presentation,
So, we actually decided to draw a picture just because we're visual learners. So for the visual learners of the jury, as you'll notice, his fence would have been near a road, which it would be natural for there to be tire marks on any road. Also, it shows that the fence posts of his fence were already rotted and that it was a windy day. So clearly this was more of a natural disaster than any fault of our own. And also, okay.
Lisa Carter. I noticed in your guys' argument that you guys talked a lot about negligent on behalf of my client, saying that because they didn't upkeep their fence maintenance, it is my client's fault that the fence broke down. I believe that the paper says due to strong winds. Now, would you or would you not believe that you yourself are being negligent in the fact that my clients comes from a low income background, only being able to sustain a lifestyle for themselves and their little dog. And then you coming from a place of privilege where you can not only have your own pool, but pay for maintenance on your pool, not understand what true negligence is when it really comes to survival of the fittest, or is it really your own prejudice that's shining right now?
I think it is your client's fault because, like you said, they were negligent. They didn't take care of their fence. That is a homeowner's duty to take care of the maintenance that they need to do on their property. Secondly, you said that, there was an issue between me and your client, but if your client has an issue, take it up with the pool company that damaged your fence, not me personally. I trusted them to come do their job. I didn't expect them to damage your fence.
So what it sounds like, this is not a question, but what it sounds like is that you recognize that the contractor was at fault for damaging the property, one, and two, that you are coming from a place of privilege and not understanding what kind of responsibilities someone with a low income background has to go through in order to survive. It's becoming very clear what you truly believe. Thank you.
Robert Chan. I noticed that you said that your fence was previously in good condition. I also noticed that you said your dog had only gotten out twice. However, they got out 3 times. Twice after the incident, but once before the incident. So clearly this shows that the fence was already damaged, which would have allowed the dog to escape. So I'd like to ask you, why do you think it's appropriate to lie in court?
I didn't lie. My dog ran away once, but after it came back home, the fence stayed and the dog never ran away again until the fence broke down. And after it broke down, because your pool company hit my fence, my dog ran away 2 more times.
Closing statement? Closing statement, please, for 30 seconds.
So it's becoming clear where the defense stands. They improperly, speculatively look at the evidence, recognizing the fact that the dog got lost before. Anyone who's had a dog before knows that it runs away. But the fact that it's run away twice since the fence is broken down and has still not returned home since, this is a poor man who has lost a best friend of a lifetime. And due to their client's negligence, has lost their friend, has lost their life, and has no means of repairing it back to what it will once be. You cannot put a price tag on a best friend. Thank you.
Members of the court, I'd like to say that if you cared so much about your best friend, maybe you wouldn't allow it in that same backyard with the clearly damaged fence. I sure wouldn't. Knowing that there may have been a hole or maybe that the fence would have been knocked over entirely, why would you leave the dog out? Maybe you should have left it inside. To me, that sounds like neglect. Thank you.
So
you guys are gonna ask.
What's up?
Oh,
Oh, yeah. So, members of the jury, we would like to ask for $25,000 damages. Breaking that down, that is $10,000 in fees. That is another $5,000 in fence repair, not only fence repair, but also damage to the curb, grass, and concrete. Additionally, another $10,000 in emotional, psychological repair for both my client and their dog. What was the name of the dog? Snorky. Snorky. The Snorky that still hasn't been found yet. We need to get like a private investigator or something like that.
I repeat, we won't put a price tag on friendship until we ask for $25,000.
Okay. Members of the jury, we would like to humbly ask for $5,000, which would be the amount of time that we've had to take off work for court duties and also litigation fees. Thank you.
This is it. Bro says there was a lot of hostility here after pulling out the character assassination. You hate poor people. Man, guys, it's really hot in this room, ain't it?
That's the you got it.
Yeah.
I motioned it down.
Yeah, I was.
Okay. I think we're the same thing. Like literally, nice little thing. Alright.
No, it's right there.
All right, you can know verdict.
Yeah, the jury has ruled in favor of the plaintiff. Thank you guys. However, $25,000, can you can sit down here? $25,000 is a little bit too much for repaired fence, grass, and concrete. We have brought it down to some of $5,000 for house repairs, and emotional support. Just please find your dog.
Thank you, the plaintiff and the defendant. No, she will find a way somehow. She will find a way.
Yeah, who's that? That.
Okay, I just realized that was the last part of the activity. We're done for the day. Before we wrap it up, I wanted to say one last announcement. For one of my other orgs on campus, I'm gonna be hosting a resume workshop on November 6th. I bring that up because a lot of you guys have come up to me, especially after the USC Law School tour, and now that we're entering internship application season, that you guys want your resumes reviewed again after our last resume workshop. So I would highly encourage you guys to attend that as well. It's open to all members, and I want to hopefully make it a collaboration with Law Society as well. I'll send out more information as we get closer to the day, but keep an eye out for that, especially if you wanna make your resume look a little prettier. I'll be hosting the event, and I don't know, I like my resume, so hopefully I can help you guys in. That's it. Thank you guys so much for coming. You guys have a great rest of your week.
Just to second that, I recommend going because he does have a nice resume. He did a little bit of a review earlier and it helped a lot of people out. So, but yeah, thank you guys.
Thank you guys.
I don't know right now.
It's late.
Yeah.
Let's just wrap. Let's just call it there.
Yeah.
All right, bye guys.
If you guys want to stay to grab a photo, you can, but you don't need to.
You feel so hot. And then I started giggling, and then you kept staring at me like you were gonna like pounce.
Wow, I'm trying to make eye contact with the jury.
That's not bad. Hey, job on that. Appreciate it. You too, bro.
Why is your phone?
I want to use it burning.
Dude, I literally want to. I don't really looks great. I like the. I like.
Hey, thank you, bro.
It looks nice.
Guilty.
You give me my suggestion.
Oh, that was you. I was wondering. Bro, since I was, bro. Yeah, lots of that. Yeah.
I told you to come.
It's cool, it's cool. Just hop in anyway. Hop in. Honorary member. Okay.
Thank you.
All right, thank you guys. I'll see you guys. Where you at? Where?
It's on here.
Because the one thing that I said was to kick him out. And guess what we did?
It's a lot. You know what? They got more money this time. Yeah.
That's like the one rule that I have for everyone.
Whatever.
All right, guys.
So it's quite exciting.
Oh, it's you, Michael.
Oh, thank you.
Thank you.
All right, Val.